28 minutes to 7 on this Friday morning. It is Morning News Today. I'm Director Thabang. Thanks so much for joining us. Let's remind you very quickly of the big stories we're watching out for you for this morning. Of course, Jacob Zuma back in the dock. That's happening in Pietermaritzburg. He's facing charges of corruption. His third court appearance, and we already know his supporters having held that night vigil, making their way to court this morning as we speak, having not slept, as we heard from our reporter Desan Tatia, who was there last night as well. And they're expecting to be addressed by the President a little later on after the court proceedings, which are expected to be brief this morning. Eskom and Labour unions going back to the negotiating table today. Wage talks dragging on for nearly 2 months now. And then, of course, the BRICS summit wrapping up in Sandton today. Fair international trade, anti-terrorism and inclusive economies dominating discussion so far. We'll bring you the latest and, of course, some analysis on that as well. But first, the Constitutional Court has ruled that workers placed in companies by labour brokers should automatically become permanent employees after 3 months. The ruling has been hailed as the biggest victory for workers in recent times. But what does this actually mean for temporary employment services? Let's unpack this morning with Thabang Rapuleng. He's from Cliff Decker Hoffmeyer Attorneys. Thabang, good morning, and thanks for your time this morning. Just looking at this Constitutional Court ruling, very brief explanation as to what it actually means and who it affects.
Well, in essence, what it means, it settles a long-standing debate on whether or not the amendments which were introduced to Section 198, capital A of the Labour Relations Act, which introduced what is commonly referred to as a deeming provision, as to whether does it constitute a deeming provision in the sense that the employers of a labour broker, once the deeming provision kicks in, become the sole employer of the client of the labour broker, or there is a dual employment relationship. So that debate has been going on for quite some time. And we've had the CCMA finding that no, in fact, there's no dual employment relationship. The CCMA found that it creates a sole employment relationship. And then the Labour Court came up and said, no, there is a dual employment relationship, basically setting aside the award of the CCMA. And then it then was appealed to the Labour Appeals Court. And the Labour Appeals Court said, no, in fact, there is a sole employment relationship. It cannot be a dual employment relationship.
You can't be sort of liable to two people or be... Okay,
so in essence, the Constitutional Court found in favor of the Labour Appeals Court a reasoning in that regard, in that it found that the moment the deeming provision kicks in, the employer, the placed employer who was initially the employer of the labour broker for the first 3 months up until the deeming provision kicks in, ceases to be the employer of the labour broker, now becomes the sole employee of the client.
The person.
Of the client. So it will be the client of the labour broker.
So does this mean now that we are going to see labour brokers scrapped? Or is it just, are we going to see that we are going to see that they have to now work in a different way, the rules change?
Yeah, I think the courts, both the Labour Appeals Court and the Constitutional Court, were careful to indicate that it does not mean that there is a ban of labour brokers. So we are unlikely going to see labour brokers being scrapped, but we are seeing their role being diminished. And it's important to mention that this really relates to employees that are earned below the threshold which is set by the Basic Conditions of Employment Act, which currently stands, I think, at just above 205,000 per annum. So for employees earning above the threshold, they will not be affected by these developments, but it's for employees that earn below the threshold. So their role will be diminished more once the 3 month the deeming provision kicks in.
Yeah.
Really, the role of the labour broker now will be more of an administrative role, insofar as they may continue to be paying the placed employees' remuneration, but they're no longer the employer. So the
company that they've placed, where they've placed this person, that company becomes the permanent employer, and this person has no responsibility to the labour brokers at all. So what does this mean for temporary employment services? Say, for example, our recruitment agencies that employ temps, not labour brokers, but established recruitment agencies. Will the same apply there?
Well, most of the recruitment maybe let me not say most, but some of the recruitment agencies operate as labour brokers as well. But all it means is that now if you are a recruitment agency and you recruit in order to place someone with a client. But this is, you employ the person, meaning you employ Thabang, but in order to place the services of Thabang at eNCA, then you are basically performing a labor broking service. But where you are maybe facilitating the recruitment of someone, meaning I take Thabang's CV, forward Thabang's CV to eNCA, then I'm not performing a labor broking service. So it will not affect those who are purely performing a strict recruitment process.
Okay, so job seekers, those who are needing a place, someone to help them find work, will not be left in the lurch. They can still go to labor brokers, but there are new rules, basically.
Yes, yes. Labor brokers can still engage employees for the first 3 months, and then if they place those employees with a client, provided that the services that the employee is performing with the client are temporary in nature, the deeming provision will kick in. And it means after 3 months, the labor broker ceases to be the employer,
step away.
And then the client kicks over.
All right, wonderful. Okay, simply put, thank you very much. Thabang Rapuleng just breaking it down for us. He's from Cliff Decker Hofmeyer, just on this constitutional court ruling on labor brokers. Well, a Cape Town